Morning, Your Honors. May I proceed?
Yes.
My name is A.J. Stanton, and I represent the Naples Estates Homeowners Association. Given the issues today, Your Honor, I'd like to reserve 10 minutes on rebuttal. I may go over, but I'd like to start there.
Okay.
For the ease of our
Okay, never mind. Go ahead.
For the ease of our discussion today, I'm going to refer to my client as the Homeowners Association or Association, and the appellee in this case as the park owner. The facts, I've recited a very complex set of facts in my brief, and I'm going to rest on that, but I do believe that the simple facts in this case need to be recited for today's discussion. So very briefly, let me go over those. 18 years ago, on September 4, 1997, the park owner joined with approximately 30 other park owners around the country to sell mobile home parks in one portfolio agreement, which we've referred to throughout these proceedings as the PPA. Now, this PPA had a lump sum price of $316 million and change. The PPA separately listed out each mobile home park within the contract with a separate contract price. The park that's the subject of this proceeding is known as Naples Estates, and the purchase price that was listed in the PPA for that park was $11,614,942. Now, at the time that the PPA was executed on September 4, 1997, my client, the association, possessed 3 rights of first refusal to buy that mobile home park. They were contained in a 1992 settlement agreement between the park owner and the HOA, a 1996 settlement agreement between the park owner and the HOA, and a recorded right of first refusal that was recorded in the public records of Collier County. I'd like to note that the right of first refusal that was recorded is unique in that once the price and terms were provided, the Homeowners Association had a 50-day consideration period to review the terms and conditions. I only point that out in case it comes up later. At no time did the park owner ever provide notice of the PPA, the terms of sale, the price of sale, that any interest was given whatsoever to accept this offer from what is now known as MHC, Mobile Home Communities. The action, this lawsuit filed in February 1998, it was vehemently defended. There were 65 defenses filed in this case. There was a 1-week trial in 2008. Following which we had an evidentiary hearing with experts to determine a price for which the park would be sold. There was a lengthy hearing concerning the association's right to an accounting to determine the rents and profits that the park owner had earned during this case. There were numerous hearings concerning attorney's fees and also, which we'll discuss today, the underlying debt on the property and how to deal with that. The major issues on appeal from the Homeowners Association are very simple. The Homeowners Association contests the price that was set by the trial court.
Let me see if I can, trying to synthesize 16 years worth, you know, is challenging to say the least, and I think we're all eager to hear everybody's side and try to get to the correct result. Is it too simplified to say that the gist of your complaint is that the purchase price has gone from $11,615 and change to $14 some odd million as a result of the way it was handled below?
That is correct.
Okay,
and,
I thought
and
so. So your main point of contention is that the Homeowners Association ought to be allowed to purchase this Naples facility for $11 million and change, which comes from the PPA, comes from the isolated price within the PPA that's arrived at through the computation of the net operating loss and the
capitalization rate.
Correct,
Your Honor.
And I believe that your opponent, the gist of their argument is the PPA is too indefinite to be enforceable, that it's got other terms and conditions about consideration that render that $11 million figure inappropriate. And furthermore, and they also take issue with the $14 million figure because under specific performance, the court wasn't allowed to sort of come up with a number. Have I outlined this correctly?
Very well, Your Honor, very well. And the issue concerning the challenge to the price, as I understood it, was that because it was a bundled portfolio,
right,
the park owner is arguing, well, the price is too
out.
low. Yeah, it's
Right.
too low. But the problem is that the evidence before the trial court was to the contrary. The PPA, the contract itself, actually used an actual net operating income, which, by the way, was the formula used by the experts in this case to establish the $14 million figure, used an actual net operating income divided by a capitalization rate to come up with the $11 million figure. And the expert testimony of the park owner, Dr. Diskin, he actually testified that in a portfolio, the entire package usually results in higher prices for the individual parks. And the problem with that testimony is that it actually shows that the $11 million figure is perhaps even higher than it should be. I'd like to, if the court, that was an important point. Volume 5 of the trial transcript, Dr. Diskin, page 722 to 726. That is correct. That is the argument.
He rendered the opinion that the 11 million may even be on the high side.
He said that the price is higher for a portfolio than the sum of the individual parks. Well, if that's true, because the package was $316 million, and that $316 million, if you add up all the individual parks, it totals $316 million. So if that's true, then that means the $11 million figure is actually too high.
Let me ask you this. As I understand it as well, you are arguing that the terms of the PPA should govern the terms of the consummation of this purchase if your clients go forward for $11 million and whatever it is, correct?
I am, correct.
What do we do about the $20 million plus outstanding debt on the property? And if you're relying on the PPA, why isn't the 14L paragraph, why can't your opponent simply pull this piece off the table saying that, look, this thing is upside down to the tune of millions of dollars because there's a debt owed here to Carno, and he was not a party. There's nothing in the record about this. What are we supposed to do about that?
Well, actually, answering your question backwards, there's a wealth of evidence in the record, starting from Mr. Carno's mouth himself, who actually testified. And I was thinking about this as I drove down here today. He actually, testifying before the court, actually submitted himself to jurisdiction before the court. That being said, there's a wealth of evidence. The PPA shows that the balance was $7 million on September 4, 1997. Of course, I'm rounding. The Carno letters that were submitted by the park owner between Mr. Carno and the park owner, who he solely controlled through his corporation, show that there was a growing balance from $7 million up to approximately $18 million, all occurring post-lis pendens and after this lawsuit was filed. And then you have counsel stating in open court, when counsel was arguing that the property should be withdrawn from the deal, that the mortgage is over $20 million, and we have, as it was referred to, the 800-pound gorilla in the room. The trial court even referred to it as a poison pill. So to answer Your Honor's question, this issue didn't exist on September 4, 1997. And what we have to remind ourselves is that this is an option contract. It's not an agreement in which two parties were sitting there and one walked away from the closing table. This is a situation in which someone sought to sell a piece of property and deprived the Homeowners Association of the right to notice of terms and conditions. And my brief was riddled with authority from this court, Wyopen, Denko, Kubitschek. I could go on discussing facts that are identical to this particular case. And these cases all stand for the position that the association is entitled to that notice. And if they don't get that notice, it's a breach by the park owner. And that breach excuses the tender of the purchase price, which of course is an issue that's raised by the park owner in this case. And I'll get to that on my rebuttal. I hope I'm answering your question, because the argument is that the credit, the authority that I cited in my brief is that—
You're asking for a credit for any amount of the mortgage that exceeds the purchase price.
I'm asking for a credit of the— if the park owner can—
It's a $7 million rough balance at that time.
The park—
How much of a credit? 20 million, 7 million, or whatever's— what is the credit you're seeking?
The case law states that where a seller recites that he or she is unable to convey a piece of property under the terms of the agreement, then the buyer is entitled to accept the part that can be conveyed and receive a credit for the value of that part that cannot be conveyed. So in this particular case, it would be a credit of $23 million. Absolutely.
But wouldn't you have to have Carno as a party to the litigation?
No, Your Honor, because every day, and I do a lot of foreclosure litigation, every day properties are bought and sold and transferred subject to existing liens. If Mr. Carno wants to step in and argue that this is a valid lien, which I've cited in my brief, this was a big step for my client to authorize me before the trial court to actually accept title to this property subject to the mortgage. The argument, which I disclosed in open court, was the judge said, why would you do this, Mr. Stanton? It's a $23 million mortgage. You're going to pay more for this property. And I said, because I've argued all along that this mortgage was a poison pill, and I believe it was put in place to interfere with the HOA's ability to obtain financing. And if you look at the face of the mortgage, it has a maturity date on it, and under Chapter 95.2281, the mortgage ceased to exist 5 years after the maturity date, which was 2009. That mortgage doesn't exist anymore.
In its current posture, the trial judge decided that if you do go forward with the purchase at the price that he arrived at, that you would take the property subject to the full amount of that mortgage. Actually,
the trial judge gave us that option, but in regards to the motion that's the subject of the appeal, which was just to transfer title subject to the mortgage because it grossly exceeds the purchase price, the trial judge said, well, you have to tender the purchase price first. And I said, Your Honor, that's not equity. We're in specific performance is a court of equity. Every specific performance decision that you review has circumstances in which, when there's the final closing, there's been a purchase price and an adjustment based upon attorney's fees, interest, rents. There's an adjustment process that goes all the way down to the bottom until the final end. And at that closing, that price has all those adjustments factored into it. I think it would be wholly, entirely inequitable for the court to require a tender without a commensurate reduction in attorney's fees, interest, and in this case, the Carno mortgage, before requiring my client to come up with a price that it may not even have to pay, that being the $11 million. Let's remember, this Carno mortgage came about because of the actions of the park owner, Mr. Carno, after the action was filed. And the case law that I've cited condemns that type of behavior. If it happened before the case was filed, perhaps I'd have a different posture on that subject.
Mr. Stanton, you're used up. You're down now, coming into your rebuttal time if you want to stick to it.
Thank you, Your Honor. I see I've covered the fourth point. I do want to cite one thing. I noticed something in my brief. This court's decision in Kubasek versus Way, it relied on the Hunt versus Smith decision, which was an Illinois Supreme Court. I cited to an earlier version of that case. I quoted an earlier version of that case. It actually went up on appeal a second time. This court was referring to the second citation of that. So there are actually two Hunt versus Smith opinions, and I say that with regards to Kuhn versus Epstein. Forgive me. Kuhn versus Epstein I cited only once. Your Honor, I'll reserve the rest of my time.
Okay.
Thank
right.
you.
You have about 9 minutes.
Good morning, Your Honor. Alan Bobo and Tom Elliott here for the defendant park owner. Your Honor, let me start just flying a little bit at the 40,000-foot mark. Part of the problem.
Would you like to reserve some time?
I apologize, Your Honor. Yes, sir. 5
5
minutes.
Cross appeal?
5 minutes, please, sir.
Okay, great.
Yes, sir. To start at the 40,000-foot mark, why we have so many problems in this case to begin with is Naples Estates was never sold. This property was never sold. A deed was never conveyed. The underlying sales contract here, the portfolio purchase agreement, was never completed. As soon as this contract was executed in September of 1997, disputes arose between the parties, so that material provisions of the contract were never completed. In fact, as counsel's brief shows, they had to enter into a supplemental portfolio purchase agreement with different parties, even to convey any of the properties at any time. So this transaction was aborted. And that's part of the problem we have with these missing material terms. The contract was just never completed after the skeletal document was signed. So the association stands and says, this is what the park owner didn't do. The park owner didn't give us notice. So the Homeowners Association also takes the position that we don't even know as we sit here today what the price and material terms are, so I don't know what that notice would be. But focus for a second on what the Homeowners Association did or did not do. The very contract that forms the basis for the right of first refusal in this case is a rent agreement. It's a situation where the park owner and the homeowner sat down and negotiated a series of 5 annual rent increases. The consideration to the park owner under that document was that the park owner would get 5 annual rent increases that it could bank on. You're a landlord. What's the most important consideration for a landlord? It's rents. So the Homeowners Association made a covenant in the form of the settlement agreement, but this is very important. That settlement agreement is not a single document. That settlement agreement is 3 documents. It is the settlement agreement itself. It is the addendum to the settlement agreement that confirms in its preamble that it is part of it, and then it is the recorded right of first refusal. That addendum to the settlement agreement says, and it is in the appellate's addendum at page 65, but it says in paragraph 2, furthermore, the homeowners of Naples Estates, by and through their homeowners association, do not waive, nor are they precluded from exercising their rights or remedies, and I'm skipping forward, to dispute all charges, fees, increases in lot rental amount that are not specifically limited by or specifically covered in said Naples Estates settlement agreement. So what did they say in the addendum? Okay, we reserve our right to contest anything we want to, but by the way, we won't contest the 5 annual lot rental agreements or lot rental increases that we've agreed to in the settlement agreement. What does the record here show? The record shows that the park owner did not get those 5 annual rental agreements, that the Homeowners Association began to escrow rent. But more importantly, for the purpose of this provision, the record demonstrates that the association in 2000 filed a lawsuit that ultimately made it to this court, filed a lawsuit contesting the very increases that they agreed they would not contest in this addendum. Now, those facts are not disputed. They're before the court. It's de novo review in looking at this contract. That 2000 case, the association said those 5 agreements that we made with the park owner that formed the consideration for the right of first refusal are invalid. The trial court below said, no, I disagree. Those rent increases were specifically agreed to by the association on behalf of the homeowners, and they are payable. Now, what happened then? That came to this court. The association appealed to this court and asked that to be overturned. This court affirmed. So this court affirmed that the association's collateral attack on the settlement agreement that it promised in the addendum it would not do, that collateral attack was legally insufficient, and those lot rental increases are due. Now, what is the effect of that? The effect is we've cited cases from all 5 districts in Florida saying that a party that is in breach of a contract is not entitled to use the arm of the court to enforce compliance on the other side. If you don't do what you're required to do under the contract, you can't ask the court to require the other party to do so. Where does that leave you? You're not without right.
Is that the 1992 settlement?
That was the 1996 settlement agreement. Yes, sir. That was the agreement. The 96 agreement incorporated and extended the 1992 agreement. You know, under the law of integrated contracts, that 96 agreement becomes the surviving contract. So we have cited to the court material case law that says if you are in breach, you can't force the other party. Now, you're not without a remedy. You still have a remedy. Both parties still are able to sue each other for breach, but through 17 years, they've not elected to do so here. So the association is in breach, and that breach has already come before this court. And the denial, the court's affirmance of the trial court's ruling against the association is in the record and is the basis for the association not being able to seek specific performance. Secondly, the right of first refusal, Your Honor, it is fundamental to a right of first refusal fundamental to a right of specific performance that a party prove that they are ready, willing, and able to purchase. Now that's record evidence. After 16 years, there is no evidence that this homeowners association is able to purchase anything. In fact, before the trial, an affidavit was given by the president of the homeowners association saying, we stand ready, willing, and able to purchase, Judge Black, for the number that you said, the $11,600,000, to defeat a motion for summary judgment. That's what she testified to in an affidavit. At trial, we said, what's the basis of that? Was the number the $11 million? She confirmed that it was, subject to any adjustments, yes. We said, do you have the money? No. Do you have a loan? No. Have you filed a loan application? No. And the court found below that the homeowners had shown no evidence that it was ready, willing, and able. As we sit here today, that record has not changed. There's been no tender, no deposit, no down payment, no loan, no mortgage commitment. More importantly, there has never been even evidence of a vote by the homeowners of Naples Estates to purchase this property. Where are we? I mean, what are we doing here? They're playing the card, Your Honor. They're playing the card that you mentioned. Give us a $23 million credit. We don't have to come out of pocket and at risk for anything. Give us that credit. We'll take the property for free. We'll turn around and try to contest this mortgage and see if we can get it for free. And if you disagree with us on this appeal, then we can walk away like a dealer walking away from a blackjack table with no risk whatsoever. That's where they are. They have not put up one single dime that is at risk. Now, the trial court settled the price term in 2012. It settled the terms in 2013. All excuses for performance are now gone. And Judge Black, I would submit to you that if what we're doing is the difference, arguing the difference between 11.6 and the $14,000 and change number, I believe that the association would have met their very substantial burden of proof to prove ready, willing, and able if they had come into the trial court and said, Judge, we disagree with your number on your $14 million, but here is solid evidence that we are able to come to the court with $11,600,000 and fulfill our pleading requirement and purchase the property. Because they pled in their second amended complaint in 2003 that they were ready, willing, and able to buy for the $11 million number, and still they've shown us nothing. On the mortgage, Your Honor, the problem with this whole mortgage issue is that the contract was incomplete. This is one of the few commercial contracts I've ever seen, especially one for $316 million, that doesn't say whether the seller is going to pay the mortgage, be it $7 million or be it $23 million. The contract literally does not say whether the seller is going to pay the mortgage or whether the mortgage is going to be assumed by the buyer. The reason is, as I started, it blew. The deal blew as soon as that portfolio purchase agreement was signed, and the necessary exhibits to specify how those mortgages were going to be handled were never done. Those are exhibits G, G1, and G2. If you look, you can look at the face of the portfolio purchase agreement. Those are missing. This court has long held, as have the other districts, that it is not up to the courts to supply missing material terms, especially those that deal with financing. I take this court's Moamco case as an example. If the contract omits the material terms dealing with existing financing, here a minimum of $7 million, maybe a maximum of $23 million, the contract cannot be specifically performed because it is missing these material terms. Now they say, give us this credit. I mean, first of all, you're correct. The third-party mortgagee is not before the court. What is the credit? What is the evidence in the record that's going to establish the credit? The argument was just made by the association that the mortgage is worthless. It has no value. So what is the amount of the credit if the mortgage has no value? In a traditional commercial transaction, what happens? Borrower number 2 makes an application to the mortgage holder. They're approved. As part of the approval process, what do? You agree to the mortgage documents that are valid, you agree to the balance of the mortgage, and you agree there are no defenses to the mortgage. And then there's a substitute of one borrower to the other. In this case, that third-party mortgagee is not before the court. There is no consent. There will be no consent. And if they say we'll simply take subject to the mortgage, where does that leave the current owner? It leaves the current owner still bound to the debt represented by the note. So you can't have just give me the credit. And then as you point out, Your Honor, 14L is a very material provision. 14L is a savings grace. Remember, this contract was put into place to effect a portfolio sale. Things were moving fast. We're throwing 35 properties into a $316 million deal. 14L was meant to say, hold the bus if, and look at the language of 14L, if the cash price, not a credit or anything else, if the cash received by the seller is not sufficient to pay both the secured and unsecured debt, then the seller can withdraw the property. 14L was a savings provision for all the sellers. It is for the benefit of the sellers. Under the argument, if you have the $23 million credit, as suggested to you today, the cash part of the sale, zero. So this homeowners association steps into the shoes of the buyer under the PPA. They're subject to 14L. So the credit will not work. Now, what happens if you reverse that? What happens if you say, well, the partnership then should satisfy the debt? Remember, the contract doesn't tell us which way it's supposed to go. So the seller, the partnership, is supposed to establish the debt, or pay the debt, back to 14L. We don't have enough money. We can't do it. The record shows that there is a substantial refusal on the part of the residents to pay the rent in this case through the pendency of this litigation. You can see from the briefs, we had money released to us from the court registry, gosh, I don't know, $1.2 million, $1.4 million, and it was released in 2002, 2007, and 2008 because there continues to be these rent wars that kind of result from this case. So there's no money to pay. Now, this debt has been around. It's purchase money financing. It's been around forever. Everyone's known for 17 years this debt's out there. There's been no effort to join the mortgagee. There's been no effort to seek any relief. So that the evidence before this court, you really couldn't determine a credit, just as Judge Hayes recognized he couldn't determine a credit without having the mortgagee before him. Now, we told you that about these omitted terms, Your Honor. I want to hit the portfolio purchase agreement is terribly complicated. We have 10,000 pages of record. I don't know, probably cited 150 cases on both sides. Let's boil this thing down to just a couple things on the omitted terms, a couple things that can easily be seen. First of all is the mortgage. I mean, it is necessary for a party seeking specific performance to prove that the contract is sufficiently definite to support specific performance. Otherwise, you have to look at other remedies. So we know that the mortgage issues were not specified. So that would have to be rewritten. Those missing terms would have to be supplied to provide specific performance. Secondly, this contract, again, is a portfolio-based transaction. There's another problem, Judge Black. If you go to the title provisions, 4A and 4C of the portfolio purchase agreement, this is a very different contract than what we normally see in a commercial transaction. Here, if the buyer sees a defect in title, the buyer can give notice to the seller. Now, in a normal commercial transaction, the seller would be required to use reasonable diligence to satisfy that problem, that title problem. Sometimes it'll say reasonable diligence and spend up to a certain amount of money to satisfy that title problem. That doesn't exist here. If the seller receives that notice, it is then up to the seller whether the seller chooses to take care of the title defect. So if a mortgage or anything else is the title defect, the seller gets to choose.
Mr. Bobo, you're down to your rebuttal time.
Okay. If the seller elects not to satisfy that title defect, under paragraph 4C, the seller can withdraw the property. To give specific performance here, the court has to rewrite that provision. So you have to supply the omitted mortgage provisions, and you have to rewrite the title provisions in order to grant the requested relief. Thank you, Your Honor. I'll save the rest of my time.
Thank you, Em. It's almost impossible to respond to all the issues that counsel brings up before this court orally. I will say that every point that counsel made was detailed in my brief. So to the extent that I fail to address anything, I'd ask the court to please pay special attention given how complex this case is to the arguments raised in my brief. So Exhibit G was raised as being a term that was omitted. It's not omitted. It's executory. The contract requires that within 14 days after its effective date, the seller must state, this is a debt that's going to be assumed, this is a debt that's going to be unassumed. The contract also provides that the parties did contemplate that the underlying debt would be sufficiently below the purchase price so that it would pay it. And in fact, Judge Hayes ruled that way. He said, I'm going to construe the debt on this property as of September 4, 1997. Mr. Park owner, you're not going to be allowed to benefit from a contract provision based upon actions that happened after this case was filed. The non-payment of the mortgage was a breach of the PPA, of the purchase contract. The purchase contract in paragraph 3, big B, little Roman numeral 3I, states that the seller is prohibited from doing anything that would cause the title to be non-conforming. Well, remember now, I didn't mention this during my opening with the facts, but Mr. Carno, the note holder who testified before the court, also controlled the park owner through his corporate, through the corporate general partner. There was no other testimony. This is a related relationship, okay? So after this action was filed, after the lis pendens was posted, Mr. Carno acquires the note personally and acquires ownership of the park owner, the Naples Estates, LCAP as it's referred to. And then the arrangement comes where the note is no longer paid. It's quite ingenious. It's something that took 18 years, maybe a little bit less, 12 years, I guess, was the point at which the interest accrued so high that it surpassed the purchase price. But it's highly inequitable to stand before this court and suggest that that act should be the source of a reward for getting out of this contract. So the point is, with regards to Exhibit G, it's executory. It says, within 14 days after the contract is executed, I'm going to tell you whether this debt is assumed or unassumed. The problem that the park owner has, it has to convey clear title. And it can't do it, it's arguing, because the debt is so big. So that's where the idea to come in before the trial court and ask the court, Judge, they're saying they can't convey clear title. You've already ruled that they're required to do it. You've ruled that the debt is supposed to be determined as of September 4, 1997. What do we do? So that's why I asked my client's permission to file a motion to accept title subject to the mortgage. And the case law is abundant from this district and the Supreme Court to support that relief. It's still risky. I don't know whether or not that's going to work, but I do find it amazing that the park owner is fighting that. If this was truly an arm's length relationship between the park owner and the first mortgage holder, you would think that the park owner would join my client in arguing that the debt is not valid anymore. But what's the risk? So it is not an omitted term. It is a term that is yet to happen. And that's the nature of an option agreement, that once the terms and conditions are known, the optionee gets a chance to perform. And we have 14 days before we know what the park owner is going to do with that debt. The prior breach argument, this is the argument that the 2000 case that came before this court, first of all, respectfully, I say this, it's disingenuous to say that there was any finding, and that's what the initial brief stated, that there was a finding of a breach by the 2000 court. That just didn't happen. That lawsuit was filed by my client. I was not the main attorney on that case, but that case represented a host of issues, and nowhere in any pleading or order in that case was there a finding, was the use of the word breach, except in the complaint filed by my client. The park owner didn't file a counterclaim. It didn't raise any defenses of prior breach. It didn't do any of that. So now, 15 years later, counsel's arguing before this court that that case stands for the proposition that my client breached the agreement. The rents were deposited with the clerk of the court pursuant to Chapter 723. I might also note that the 1996 settlement agreement that was the subject of that lawsuit authorized the deposit of that money to the clerk of the court. And that money was turned over to the park owner when my client lost. I seem to recall, along with a lot of attorney's fees as well. Park owner was made whole. There's one count remaining, of course, and that is the fact that the park owner did not complete the kitchen repairs. And it admitted in its motion for summary judgment in that case that it didn't complete those repairs until March 8, 2001. Again, this is in my brief. That was 4 years after the PPA was executed, after the right of first refusal was triggered. So again, we're talking about post-option actions as a basis for avoiding liability. And that's just, again, inequitable. It's been inequity since we started. In fact, I would argue that inequity is why we're here 18 years later, because my client has had to do nothing but catch fly balls left and right from the park owner. Even if the 96 agreement, if this court felt that my client breached the agreement, which there's no evidence to support that, there was a 1992 settlement agreement. I disagree with counsel's representations. It was not incorporated. It was referenced, but it was a freestanding agreement on its own. It also gave rights to, freestanding rights to an option to buy the park, along with the recorded right of first refusal. The only way that the park owner can avoid those two agreements is by bundling them in with the 96 agreement and argue there was a breach. I want to also point, I've already noted that the park owner breached the 96 agreement first by failing to make the repairs, and it admitted to that in its motion for summary judgment in the 2000 case. Tender, this court, Brenner versus Duncan. Michigan Supreme Court, this court accepted that case in the Denko versus Belt decision very clearly. In that case, the ruling was where an optionor fails to give an optionee notice of the price and terms of a contract and sells a parcel to a third party along with others, the optionor is prohibited from raising failure to tender as a defense to liability. This legal principle, it's not been refuted in the briefs by the park owner. The court further ruled that the failure to give notice is a breach of the option and excuses the optionee from tender until the price and the terms are finally set. We are still not finally set. I'd quote the court that stated, "A party who prevents fulfillment of a condition of his own obligation commits a breach of the contract and cannot rely on such condition to defeat its liability." The trial court, Judge Hayes, he referenced this ruling in his justification for finding that the association was excused from having to tender. And in fact, the court stated, "It is inequitable to require the plaintiff to demonstrate its ability to perform an agreement that the defendant denies exists and has frustrated by combining with the pertinent terms and the terms applicable to the sale of other mobile home parks." And the court went on. That's in my brief. In summary, I'd like to point this out to the court. September 4, 1997, if the park owner just did what it was supposed to do and give my client notice of price and terms and conditions of sale, we wouldn't be here today. But instead, the park owner thought, well, we can probably get past them, and maybe they won't find out. Well, they did. It took them a year to find out, and then it took, the record shows, 3 years to find the contract. And here we are now. And now the park owner wants to make a bunch of arguments that all came up post-Liz Pendens, post-filing of this lawsuit, as a basis for getting out of the deal. That's not equity. It's not consistent with any of the decisions of this court, which 75–80% of the decisions in my brief came from this court or the Supreme Court of Florida on this very issue, bundling a subject property, not giving notice, and having to extract the terms out of the bundled contract and apply them to the subject property. That's the challenge that this course faces. This is the only court in the state of Florida that I could find that dealt with this issue as immensely as it has. I thank you for the time that your honors have given me today. Thank you.
Thank you, Mr. Stanton.
Your Honor, the claim was made that this is not equity. Yet the argument before the court today is, give us the property for nothing, and now we'll fight the mortgage and declare it to be invalid. This is the same association who failed to pay the money that it agreed to pay under the settlement agreement, and now it says, how did the mortgage increase? The mortgage increases because the revenues are not coming in, because the residents refuse to pay. The argument is made that that addendum to the settlement agreement was not part of the settlement agreement. It was an independent standalone document. Here's the preamble. This addendum was entered into this 30th day of April, 1996, prior to the final signature of the 5-year Naples Estates settlement agreement for the purpose of inclusion of this addendum into the final settlement agreement. The parties agree to the following statements, and then it is agreed that this homeowners association and the residents will not contest the 5 rental agreements that form the consideration to the park owner for the 96 settlement agreement containing the right of first refusal. And you can see from the documents that are in the record, you can simply look at the face of the complaint filed by the homeowners association in 2000, and you can see on the face of the document that the homeowners association, on behalf of the homeowners, contested the very consideration forming the basis of the parties' contract. So one other thing about the rewriting of the contract, and I'm glad it was pointed out to you, when we look at those 2 provisions that I just argued a second ago, 4 dealing with the title to the property and 14L, the argument was made that the park owner is supposed to provide the property free and clear of all liens and encumbrances. That's not what the contract says. The contract says free and clear of all liens and encumbrances, subject only to assumed underlying mortgages that were supposed to be specified. They never were. That's the material terms that would have to be supplied. Now, in 4C, the argument is made that the court limited the title defects to those in existence on September the 4th, 1997. The trial judge here was wonderful. This was an error. Think about it. The trial judge is saying that the title defects are supposed to be as of the date of the contract and has rewritten the contract accordingly. Title defects are viewed as of the date of closing. There's 35 properties to close. These closings may take months or years. You can't draft the contract so that the title defects exist as of the date of the contract. They exist as of the date of the closing. When you look at 14L, the same thing is in 14L. The court has said that we are supposed to view whether the cash portion of the purchase price is sufficient to pay off all the liabilities. And it says that's supposed to be determined as of September the 4th. Well, the liabilities weren't going to be paid. If this contract had gone forward, there's going to be a closing months or even as much as a year later. Some of these properties closed many months later. You can't limit 14L to that date. The court effectively rewrote the contract and rewrote it incorrectly. Tender, Your Honors, the case law sometimes confuses the term tender with ready, willing, and able. I agree with the portions of the association's brief that suggest that it's not incumbent upon a buyer to grab a check and to chase the seller around and say, take it, take it, take it. That you can be excused from tender if the facts appear that the seller would never have taken the check. What you are never excused from is proof that you have the ability to purchase. That's a fundamental requirement of a specific performance action, and if you look at the case law, it is direct. The ability to purchase must be demonstrated as of the time the contract is entered into. So if this association wanted to take the position that the number that it should pay is $11,600,000, it is fundamental that it had the burden to show that it was ready, willing, and able to purchase for that sum of money. As this court recognized in the Amber Glades decision, this is a mobile homeowners association. This is often an assetless entity. So it is even more important in this situation for this group to show that it has the ability to purchase, because as of right now, there is not one thin dime that is at risk.
Okay, Mr. Bobo, your time is up.
Thank you all. I appreciate your time.
Okay. We'll take a break. Court will be in recess for 15 minutes.